All right. Good afternoon. It's great to hear so many lively discussions over lunch, and we're now excited to welcome you to our policy panel. My name's Ariel Zetlin-Jones. I'm an associate professor of economics here at the Tepper School of Business. I'm also one of the 3 co-directors of our Secure Blockchain Initiative, which is why you've seen me asking so many questions throughout the last 2 days. As an economist, my interest in blockchain lie deeply in the fact of the role economic incentives play in securing and building blockchain applications. And so this intersection of computer science, distributed systems, and human behavior is really what draws me to this space. It's also human incentives, economic incentives, and human behavior that sow the seed for the need, perhaps, for policy responses to the types of activities we see coming out of blockchains. And so given these interests, it's really my pleasure to host this panel on policy. And in speaking with our panelists, I think one of our big goals for today is try to uncover a few critical risks or opportunities that blockchains pose for traditional regulation. And in doing so, try to understand what is shaping the policy response to this emerging technology as it evolves, so we can better understand perhaps what risks regulation poses to blockchains and people building on those applications. Okay? And so with that introduction, let me briefly introduce our panel, and then we'll dive into some topics. So at the far end, we have Chester Spatt. Chester is the Pamela R. and Kenneth B. Dunn Professor of Finance here at the Tepper School of Business. Chester is a highly influential scholar researching financial economics and financial markets. He's a leading expert on market structure and trading, mortgage valuation and contracting, taxation and asset allocation, and financial regulation. He also served as chief economist of the U.S. Securities and Exchange Commission from 2004 to 2007, and so I think we'll appreciate hearing his views on where he sees regulation coming for blockchain. Next to me, we have Peter van Valkenburgh. Sorry, we got our seats a bit flipped. Peter's the research director of Coin Center, which is the leading nonprofit research and advocacy center focused on the public policy issues facing cryptocurrency and decentralized computing technologies. Peter leads Coin Center's efforts to produce and publish policy research, to educate policymakers and the media about cryptocurrencies, and to advocate for sound public policy. And so we're excited to hear how Peter sees where he sees policymakers coming from in his discussions trying to educate them on what cryptocurrencies and blockchains are. And in the middle is Thomas Ruchti. Tom is a research principal at the Office of Financial Research. In case you weren't sure, the Office of Financial Research resides within the Treasury Department and helps to promote financial stability by looking across the financial system to measure and analyze risks, perform essential research, and collect and standardize financial data. Tom was also formerly our colleague here as an assistant professor of accounting, and his research really focuses on how firms and markets and policy responds to information and information design. And so we're excited to have Tom here to tell us financial stability issues related to blockchain and crypto. So I'm excited really to see the unique perspectives our panelists bring today. Please join me in welcoming them to our policy panel. So if it's okay, I'd like to start with Chester, and perhaps you could share some of your views. So as I mentioned, Chester is a leading expert in financial regulation. Your time as chief economist at the SEC, I imagine, shapes your views not just on theory, but also the practice of financial regulation. And so I wonder, would you provide us a little perspective on how you view regulation broadly and how this applies to some of the challenges in particular in the crypto space?
Yeah, happy to do so, and delighted to be able to speak today. I thought first I would take a moment to provide you a little bit of context with respect to my background. So I've been a long-time faculty member here at the Tepper School, but I also had the opportunity to serve as chief economist at the SEC from 2004 to 2007. Obviously, there was no such thing as blockchain in that era, but it was an era in which Regulation NMS, which is the prime regulation governing our equity market trading, was adopted and implemented. And since then, I've been a member of a number of federal advisory committees, including the SEC's own Equity Market Structure Advisory Committee, the Office of Financial Research's Advisory Committee, and the Model Validation Council of the Federal Reserve that critique stress tests. And I've also been on various outside advisory groups, some of which have been quite critical of federal regulatory policy. So let me begin maybe by describing a little bit of the SEC's attitude about regulation as I see it. So a lot of my expertise is in the equity space. the regulation of trading, I think, has reflected, in recent years, has reflected relatively limited appreciation of the importance of segmentation and how that benefits retail investors. Basically, retail investors are getting better prices than institutional investors because the markets understand that these investors are not very informed, and so there's much more competition. The way our market structure is set up, there's much more competition to trade against retail as opposed to trading against institutions. And in fact, even within retail, the firms with the less sophisticated customers, like Robinhood, seem to get better execution than the firms with more sophisticated retail customers, such as Interactive Broker. Their customers seem to get worse execution because their trading against them is less valuable. The SEC, meanwhile, has been indirectly challenging payment for order flow and dark trading. Surprisingly, they've called for order-by-order auctions for retail trading. At the same time, there's been relatively little focus, remarkably, on the bond market and options markets, where there's probably more scope for improvement than there would be in the equity markets. The focus in crypto has been on enforcement, as you probably read about, and maybe some of your firms are, of course, involved. The SEC has brought a variety of enforcement actions, and some of this is sort of focused on anti-fraud issues, but arguably somewhat broader. And the other point that I would emphasize with respect to the SEC's attitude, the SEC has really been encouraging firms in this space to come in and meet with it, but it's a little bit of a kind of a mixed bag to meet with them. One of the complaints that one hears is that firms come in, the SEC doesn't provide much feedback, and then sometimes the SEC brings enforcement actions based largely upon what it heard. In effect, the SEC likes to be a last mover after encouraging firms to engage, and this is, I think, one of the main criticisms in the crypto space. Of course, there's many opportunities, many economic opportunities for the blockchain. It facilitates record keeping without a central authority. It facilitates disintermediation and has many applications, particularly in financial services, to the trading process, to clearing and settlement, to payment mechanisms. And it raises some interesting issues with respect to privacy and anonymity that I think are important. Now, more broadly, why do we? So that's some of the roles of blockchain. Now, why do we regulate more generally? Well, in economist parlance, we regulate when we think there's market failure. And there's a variety of circumstances which would potentially lead to market failure. Externalities, so basically interdependence between the economic agents, adverse selection or private information that leads to some breakdown of markets, moral hazard or really incentive conflict. What's the purpose and role of regulation? Potentially to protect investors, consumers, and to discourage fraud, to discourage manipulation. Now, it's possible, certainly possible, given the differences in the nature of the structure of blockchain, that blockchain could lead to new sources of market failure within, for example, these types of domains, given the decentralized structure and private information. And this is something that the SEC ought to be an important focus of the SEC as it develops its regulatory framework. Now, what are some of the tools that are used in regulation? Well, broadly, I think of some of the tools as the rule of law, property rights, disclosures. In fact, the SEC's framework is primarily disclosure-based, except to the extent that it's also very focused on bringing enforcement actions, in the crypto space at least. Anti-fraud rules, certain prohibitions, compliance exams, and liability rules. These are the types of tools that are being used. Now, should regulation differ? Should it differ from the traditional regulation? Should the crypto regulation differ? Well, this is, I think, a difficult issue. The standard approaches point to some baseline perspectives. Indeed, fintech potentially offers, and at the same time, I think there needs to be a recognition that fintech offers much more, and the blockchain in particular offers much more than just regulatory arbitrage. Some critics think, oh well, it facilitates evasion, but I think one needs to focus upon what are the innovations that are really coming out of this, and how does one blend those into the regulatory framework? Now, the context for fintech is different. It leads to some unique challenges. At the same time, I think it's important to allow innovation and facilitate adaptation. Anonymity is certainly an important issue. It can lead to additional scope for additional fraud, possibly adverse selection, and it highlights the importance of KYC, knowing your customer. I think also these issues, all these issues in context illustrate that learning is important. Learning by the regulator and learning by the innovator. I think, unfortunately, the nature of the way our regulatory regime has evolved, or really not evolved, I think it's really undercut the learning, because if you had some sort of at least preliminary regulatory regime, I think that would facilitate learning by both the regulator, whose learning I think is somewhat limited because of the way they're not really engaging in the case of the securities, in the case of the SEC, but also learning by the industry in terms of how to adapt and how to design things. So what do I see as some of the underlying challenges? Well, obviously, I think it's important to embrace the challenges, for the industry to embrace the challenges. I think privacy and anonymity, a key issue. I think anti-fraud rules, a key issue. The important, one of the things that's a little bit atypical about blockchain is it really highlights the cost of creating and recording data in real time. Some of that has to do with the cost of electrical power, the location of the mining activities, the global nature of the product, and the need for verification and replication. And these are kind of real costs, but they obviously produce also considerable benefits. These are, I think, important issues in the regulatory context that are kind of a little bit different than the traditional context. I think also the problem of what I'll call the problem of passwords and custody. So here, in this context, you don't necessarily have independent custody of securities. I think this is an important issue that regulators and the industry, need to figure out, I think, clean solution to. And okay, and so let me just take up one example before I wrap up. Anonymity, I think, is an important issue. There is the possibility of vulnerability to illicit or even terroristic activity. Anonymity also may lead to potential to evade taxes. But on the other hand, this is actually also part of the decentralized structure. How do we feel about anonymity from each other? How do we feel about anonymity from the state? What's good, what's bad? I think some of these issues are still issues where there's uncertainty, or at least where I think these issues have not been fully sorted out. How would our traditional regulatory framework apply in this context? Should we tweak that framework? And finally, I'll just note that we have many regulators. There's in Washington, particularly in the financial space. Congress has an important role. To some extent, the framework is not really very clear. The jurisdictions of these regulators, a little bit clearer, but not that clear. And there's different kinds of objects. There's currencies, commodities, securities, exchanges, all having somewhat different regulatory regimes in the traditional way. Just to point to one of them, in the securities context, there's something called the Howey test, which now goes back 3/4 of a century. It was a Supreme Court case. The case focused on what was the definition of securities, obviously having nothing to do with crypto directly, but this is sort of the SEC's framework. This is what the framework that they're using today. It focuses upon the expectation of profit from others, but I think there's some serious questions as to whether this is a dated or really outdated framework. So anyway, that's sort of my overview about regulation. Let me turn it over to the others.
Thank you so much, Chester. I'm excited to dive back into some of the topics you raised when we have a chance to have a more open discussion. Peter, as I mentioned, you've authored a number of articles as research director at Coin Center, explaining in plain words how blockchain technology works and how cryptocurrencies impact issues like privacy, financial surveillance, innovation, consumer and investor protections. Maybe for the audience, and certainly myself, could you tell us a little bit about Coin Center and its goals, but also what you see as key legal concerns or priorities for those working in the blockchain space?
Sure. So Coin Center was founded in 2014. It was actually my second job out of law school, and my first job was only a few months long, so I kind of hit the jackpot because nobody was doing public policy work in crypto at that point. And the few organizations that existed had sort of taken reputational damage. Some of you may remember there was a Bitcoin Foundation at one point. A number of their board members and their board of directors ended up in prison and things like this. So there was this need in 2014 for some credible voice in Washington, D.C. to explain how these technologies work in plain English and to raise and discuss legal implications, like how do existing laws, like securities laws, like the 750-year-old Howey test, how do these laws potentially apply to these new technologies? And to explain to Congress how maybe there's areas on the margins or maybe wholesale changes that could be made to the laws to either facilitate innovation or protect investors from new emerging risks or prevent terrorist activity and things like that. So there was a lot of work to be done, and I was very lucky to be Coin Center's first and still only director of research. Since then, I've had the opportunity to testify in Congress, to brief members of EU Parliament. I've gotten to explain this technology to all kinds of folks and learn more about it myself in the process. I feel very lucky, incredibly lucky to have had that opportunity. What I would say is probably the key challenge in this space from a public policy standpoint, and building on Chester's excellent depiction of the field of how regulation works, and generally what are its goals and objectives and what are its tools and how does it actually function. Chester mentioned property rights, liability rules, many other disclosure regimes, many other devices that we have in our public policy toolbox to get at the particular ills that we're trying to address, whether they're money laundering or fraud or things like this. There's an unspoken tool, or a less spoken tool, perhaps, that's always been sort of central to the late 20th century or early 21st century regulation. It's this assumption that most things that are of consequence that happen in the global financial system will happen through an intermediary. And this was just an inherently obvious thing back in the 1970s or 80s or 90s. You simply couldn't have a stock exchange that would still work on sheets of paper, on certificates. So you had dematerialization, you had clearinghouses, and now you don't have a bearer instrument that is your shares in Goldman Sachs. You have, a claim to a bearer instrument that's sitting in the basement, or maybe not even sitting in the basement anymore, of the DTCC in New York. And now you have what you would charitably call an intermediary, but if you are not so charitable, you might call a choke point. And the choke point is the government's low-cost way of enforcing public policy. We don't need to regulate every person directly who's engaging in activities that we're concerned about in the global financial system. We can regulate a single party or a series of single parties in a lumpy marketplace and enforce our will that way. And so whether it's securities laws with the SEC and investor protection concerns, where we regulate exchanges and we regulate brokers, dealers, we regulate clearinghouses, or whether it's in the anti-money laundering area, a completely different public policy arena where we're worried about criminals getting the benefits of their criminal activities and hiding the proceeds of their crimes. We regulate banks, we regulate money transmitters. We impose our desires for good public policy on those intermediaries, and we rely on their power as an intermediary to get a cheaper or a more affordable version of the public policy result that comes out the other end. And so this is the way things worked, and worked reasonably well. And cryptocurrency creates a real challenge to that system. Cryptocurrency puts us back in a world where a person can pay a person in Singapore potentially, hundreds of millions of dollars in a single transaction with no intermediary to speak of. At least not a real intermediary in the traditional sense. To the extent there's any intermediary, it's going to be some person running a computer on a peer-to-peer network, and that person's not even essential to that peer-to-peer network's continued operation. They're just one of many parties mining cryptocurrency and validating the blockchain. And if you try and regulate that person, 50 other people will pop up, and they'll continue to do what you didn't want that person to do. So we are effectively back in a world where you don't have these choke points. And that leads to all kinds of public policy questions and hard discussions. Just to get onto the anonymity topic briefly, we have a highly surveilled financial system. I think a lot of Americans don't realize that while they have a lot of privacy rights over the documents they keep in their home office, Like the police have to get a warrant before a neutral magistrate before they can come into your home and take your papers. No such protections exist for your bank account records. A mere subpoena from an investigator with no judicial oversight can obtain all the information about your financial activities at JP Morgan Chase. And that's fine constitutionally because of something called the third-party doctrine. Well, that anti-money laundering system, which says we're going to have the banks report on their customers' activities so we can identify criminals moving money through the economy, is posed with real challenges when now people can move money without those intermediaries to do the financial surveillance, and constitutional challenges wherein trying to surveil people doing these things directly actually would require a warrant, just like they'd need a warrant to search your home office. And so this is a single example of many wherein the disintermediation of the financial system that cryptocurrency technologies allow for, mashed up against our constitutional rights and our regulatory structures, make outcomes hard to predict and uncertain, and also open a lot of opportunity for things like the protection of human rights, the protections against overzealous state surveillance, our anonymity vis-a-vis our government, as Chester said. So that's kind of the work that we're embroiled in at Coin Center day to day. We have 2 lawsuits against the US government right now, both suing Treasury, sorry, not your part of Treasury, the IRS and OFAC, which are completely different parts of Treasury. And yeah. So, with that segue.
Thanks. I've been reading a lot of Peter's work because, having had to talk to some local representatives, of course, you explain blockchain to them, you ask, is that clear? And they say, clear as mud. And you can guess what gets quoted in the newspaper. So Peter's work is very helpful for how to speak to policymakers. Tom, as I said, before your time at OFR, you were an accounting researcher here, and your research still today seeks to understand how accountability and transparency standards shape the behavior of banks and other corporate institutions. Through your work at OFR, can you give us a sense of where it relates to blockchains? Are you viewing, or to the extent you can, does the office view blockchains as an opportunity or risk for accountability and transparency standards?
My microphone is working. So, Ariel, thank you so much for the introduction. I haven't read from a script before. I've given hundreds of talks, but I've never read from a script before, but I'm a federal employee, so I've got some constraints. Anyway, I'm going to give a disclaimer now, and then I'll try to dive right into your question. So first of all, the views and opinions expressed here are those of the author and do not necessarily represent official positions or policy of the Office of Financial Research or the U.S. Department of the Treasury, whom Coin Center is suing right now. So the Office of Financial Research was established by Dodd-Frank in 2010. And this was in the wake of the financial crisis, 2008. So I'm really just giving this history and background to sort of speak to what our research, but also policy orientation, though we don't make policy. Our goal is to support Financial Stability Oversight Council and its member agencies. So if you think about the SEC, the Fed, FDIC, OCC, all of the regional feds, they're members of these financial stability concerned institutions, and we're kind of the background think tank behind them. Or we also collect data, and our greatest passion is trying to establish a repository of meaningful data on financial exposures and I guess you could say connections. So at the office, because we're focused on financial stability, we're naturally drawn to the largest financial institutions. So you could think about banks, but also non-bank financial institutions, private funds. We're interested in central counterparties. We're interested in connections between these. And so where do I fit into this? I am an institutions guy. I care about accountability. I care about transparency. So one area that I'm trying to do some research is looking at the institutions of crypto. So those that are providing services to people in the financial space of crypto, let's call it. So blockchain is decentralized. Nobody's confused about that. It's decentralized, it is emergent. However, the simplest way, you think about the typical investor, and I don't know if this is a law of crypto or of this type of emergent system, but the typical investor is not let's say, so sophisticated as the typical blockchain aficionado. All of that is to say, they invest in crypto typically through a centralized intermediary. And so this could be an exchange, or in the case of recent happenings, a spot Bitcoin ETF, as approved by the SEC very recently. So one area that I'm looking into is firms and their losses during crypto winter. So there's actually quite a bit of novelty in the blockchain space. But if you look at a lot of these services that are provided, they have, if not a direct mirroring, they have an analog in the financial space. So you could think about crypto lending, centralized exchange services, and so could be crypto for fiat or crypto for crypto, custody services, which is a big thing I will actually come back to in a little bit, and boutique investment advising and strategy advisory. These all exist in the crypto space, more or less focused only there. So I'm personally interested in which business types are the more resilient and the less resilient. And these institutions actually register as money services businesses. And so they're under supervision of state agencies, but it's different than the framework that we see for typical financial institutions that are doing this type of intermediation. So what is interesting to me regarding these institutions is that this means they just don't face the same accountability and they don't have nearly the same transparency standards. So that's one area of research. Another, and I'm going to try to wrap up quickly because I know we have topics to get to, but I'm also working on a working paper having to do with funding. So at the office, we care quite a bit about funding. And so what is funding? That's just the money provided to make the machine run. So you could think about lending is dependent on funding. You could think about staking is a form of funding. So proof of work uses all this energy. How do you validate transactions? Well, it's this all-pay auction called the secure hash algorithm. You have to solve it, and then whoever solves it first gets to propose. Well, in staking, you follow the Satoshi, and that's how someone is allowed to propose. But how are they allowed in this pool? They have to submit 32 Ethereum for the Ethereum chain. That's about $100,000 right now. So significant contributed capital. We just ask, what if there is a run? And it's a theoretical paper, still developing some of the results, but aside from these cryptographic trade-offs, we could look at proof of stake. The majority of billion-dollar cryptos are proof of stake now, but they are susceptible to this funding risk. And so that's of interest to me at the OFR. And so I have more that I could say about transparency. I think that I'd really just like to highlight that transparency is a matter of degree, not quality. And what I mean by that is we're constantly, quote unquote, improving transparency through time. If you think about prior to the mid-90s, a typical investor could not access public filings of companies without going to one of the 3 reference rooms in Washington, D.C., New York, or Chicago, or being yourselves an institutional investor. So prices used to be in a much earlier era, used to be quite disparate across regional exchanges. I think we depend on centralized intermediaries naturally in a lot of financial markets. In blockchain relevant institutions, it is by definition impossible to have a centralized price without there being some measure of centralization. And maybe that could be algorithmic, but again, who has access to that information? It's a matter of degree, not quality. How transparent a lot of the interlinkages and a lot of the prices and relationships are in this space. And so I could go into my dumb examples of FTX and Bitcoin ETF issuers, but I think I'll wrap it up there.
Thanks, Tom. I think something you've all discussed in a couple different contexts is this issue of anonymity, privacy, transparency. It also relates to something Carol House brought up this morning, that the pseudo-anonymity of blockchains creates risks, but they are public immutable ledgers where we produce a lot of public information, which also creates opportunities. And so I guess what I'm a little curious about, as Chester mentioned, I'm of course as an economist sympathetic to it. We think about regulation often driven by externalities. When I think about regulation in the crypto space, are there new trade-offs between privacy and transparency? New trade-offs between anonymity and that we think might cause kind of new types of regulation to emerge, or is it the traditional regulations we need to think about? We just have to think about them in a more sophisticated way because the tools at the regulator's disposal is different. I'm curious if any of you have perspectives on that.
I think in the early days of crypto to more recent times, I think there's been an assumption that there is a new opportunity for trade-off in that more transactions will happen on a public ledger. And because they're on a public ledger, maybe the need for robust identity of the participants actually decreases because you can observe the activity. And speaking with Mike Mosier, who was interim director at FinCEN and has been both in and out of government and the blockchain analytics space, he will say that, look, you get much more value for your regulation or for your anti-terrorist policies identifying a series of transactions as 99% Hamas likelihood than you do knowing the name of the guy who might be at Hamas. They don't care about the name of the guy. If you can see on the blockchain a series of transactions and identify it as terrorist financing, you can ring fence that. And when people want to go cash out of the system, which will be through centralized organizations, institutions like Coinbase or Kraken, you can just deny people the value of their money at that on-ramp or off-ramp. And that is a new paradigm. Rather than robustly knowing exactly who everybody is on this network, you can identify bad activity and then prevent people from moving off the network or moving onto the network. That was an interesting paradigm, and it still is an interesting paradigm, thanks to Chainalysis and these blockchain analytic companies that can identify activity on the public blockchain. The problem is that this is an interim state of the technology. Nobody wants a global financial system where the guy in the cubicle next to you can see on the blockchain when you get paid your salary. Nobody wants to have Venmo for all of your personal intimate transactions, default public, you see everything I do and all the little messages I send. JP Morgan does not want its proprietary trading strategies to be aired on a public blockchain. So nobody, whether it's a criminal, a normal person, or a corporation, or a criminal corporation, is interested in a fully transparent system. And of course, I don't need to tell a room full of cryptographers, there are a lot of better alternatives than a fully public ledger. You can use zero-knowledge proofs, you can use rigged signatures. You can do a lot to get all of the integrity of the blockchain that we expect from Bitcoin as far as non-repudiation and no double spend problem, but not have clear information about who paid who and how much. And so when we look today at the first generation of privacy blockchains like Monero and Zcash, and the more recent generation of privacy blockchains like Aleo or Enoma, or the sort of intermediate step, which I would call Tornado Cash, built on top of Ethereum, you're faced with these really hard problems. Now we have true anonymity and yet integrity of settlement or of data on chain, and how are authorities, especially in the terrorist financing context, going to deal with that? And so I'll briefly wrap up my thinking on this area by just pointing to the Tornado Cash example. One of the two lawsuits that Coin Center is bringing, we're suing OFAC, which is the part of the US Treasury that does sanctions, which is you can't pay people in Iran, that sort of thing. OFAC added the Tornado Cash smart contracts on the Ethereum blockchain to the SDN list, which means Americans are no longer allowed to send or receive any money from that address. Now, that would be fine, in my opinion, if Tornado Cash was a fully centralized, ordinary money services business like Coinbase. If they're laundering terrorist proceeds, they are people. They can be subject to US sanctions laws, and they should stop laundering terrorist proceeds. The problem is that the Tornado Cash smart contracts that they added to the SDN list are immutable smart contracts under the Ethereum blockchain. They are an algorithm that has certain basic rules of fundamental rules of operation. You give it money, it locks it. The only person who can unlock it is you using the deposit note that it gave you. There is no person there. And so this, in our opinion, actually goes against OFAC's statutory authority. They have authority from Congress to sanction persons and the property of those sanctioned persons. An immutable smart contract that can't be altered or changed or controlled and doesn't enrich anyone, sanctioned or not, can't go on the SDN list. And once we go down the road of saying, oh, well, OFAC can sanction any protocol, even if it's not owned or controlled by a person, we go down the road of saying that OFAC, this department within Treasury, can essentially tell Americans which open source software stacks they can and cannot use. Whole protocols. They can't use Bitcoin. They can't use Linux. I don't know why they would go after Linux, but in theory, that would be within the breadth of their jurisdiction if this interpretation of the law stands. Simultaneously, there's a criminal case against one of the developers of Tornado Cash. His name is Roman Storm. It's in the Southern District of New York, and he's being charged with conspiracy to launder money, evade sanctions, and run an unlicensed money transmission business. As alleged in the indictment, all he did was publish the core contracts that are the Tornado Cash smart contracts and didn't actually get directly enriched by that in any way. If that's the bar, you publish open source software to a blockchain, you can be held liable for criminal conspiracy to violate sanctions laws, then a whole lot of software developers are suddenly potentially on the hook for violations of all kinds of criminal conspiracy type charges. So these are very consequential battles that are all now happening around this anonymity topic, and a lot is at stake.
I think I want to come back to something you mentioned in a minute, which is I think the notion of an institution when you allow for smart contracts changes. And the notion of a centralized smart contract that is just deployed to this decentralized network, do we need regulation for that, and what does it look like? How does that replace institutions that Tom said look like standard centralized institutions that offer services? I want to come back to that in just a minute. But I'm curious, Chester and Tom will tell me, I'm sure, we've been debating the right amount of information to disclose in corporate contexts and banking contexts forever, right? You can't issue stock to the public and reveal no information about your business. So do we view this as a need for regulation, or will the market kind of decide the right amount of information to provide, even if they could use fully private, secure, kind of encrypted blockchains? Do you have any views on where we might end up here?
This microphone. Yeah, sorry, I love. So will the market provide the right information? So I think on this I'm the two-handed economist. On the one hand, on the other hand, markets. I think markets do encourage information provision to the extent that market participants are interested in it. At the same time, you look at the structure like the overall regulatory regime from the SEC, and much of it is focused on disclosure, and I think the underlying presumption there is that perhaps markets aren't quite supplying enough of it. And certainly, I think in certain contexts, that's probably true. So we have sort of supplemental rules and laws about how much disclosure should be required. What are sort of minimum standards? Whether it's about the fair disclosure and whether companies can make selective disclosure to issues involving insiders' trades. And even to the extent that those trades are legitimate, that they be disclosed, that the trades of insiders be disclosed in a timely way. So we have rules regarding trading activities by insiders around earnings announcements. So we have a whole series of rules. So that's certainly suggestive that maybe the markets don't quite provide enough. Now here, I think one of the challenges is that the technical issues, and I think we heard a great description of some of these technical issues and challenges. They may well not align so well with the market imperatives, and it may take us a while to get these issues right. Maybe that's not so surprising. Just in the news today, there's a kind of a disclosure-oriented issue that was sort of big in the news, which is that Elon Musk is going to seek a special vote so he can get his $55 billion compensation package that basically a Delaware judge ruled wasn't adequately disclosed, and where there was underlying conflict of interest. And I think it's illustrative that maybe the rules in these spaces, they're complicated. They lead to complicated issues and challenges, and they may not align so well with the the technical issues. And so it may be that over time we need to revisit. That's certainly suggestive that over time we may need to revisit exactly what the rules of the road ought to be.
So from an anti-money laundering perspective, I know your customer is important, but it might even be important for financial stability. One element of know your customer is suitability, but another is understanding the risks of dealing with a counterparty. So we care a lot about counterparties at the OFR, and all I really want to highlight is that if you are depending on a counterparty to be there, maybe in good times they're there and in bad times they aren't. That could have some financial stability implications. There are potentially externalities of that, but maybe many of them are internalized. And so this question of anonymity might have a role just for overall market functioning. So I just have questions like, does this become more or less challenging with greater or overbearing oversight? Are the risks more difficult to consider if regulators do not require know your customer for crypto transactions? And so yeah, that's, otherwise
Two quick responses. On the what information should be disclosed, and do markets or regulators or policymakers have a better idea of what information should it be? I think one of the things that you see in the cryptocurrency public policy space is a chafing of the securities laws and its particular disclosure regime focused on things like capitalization, things like that, and what seems to matter to a lot of folks in crypto, which is, I want to see the open source software. I want to see the code. I want it audited by 3 or 4 different firms. Not that you can even find multiple firms that will audit smart contracts to know that the software is doing what it says on the tin. So we often say well, crypto doesn't need the disclosures rules because it's all open source software, but actually it'd be really helpful if you had a disclosure regime that required some sort of audits of code quality or things like that. So this is an area where the rules that we set back in you could go all the way back to the 30s, but also the more updated disclosure rules of the last century and a half or century and a quarter are slow to update and therefore lag behind maybe what markets would prefer to see as far as information disclosure. Not that it's necessarily a fool's errand to update them, though. Then as far as counterparty risk and know your customer, I think you're right, especially in the legacy financial system. The interesting thing about DeFi is that counterparty risk often does exist in very substantial ways when people have pretended to be decentralized and actually aren't. So look at an FTX or something like that. But if you look at something like Uniswap or some of the other more widely now used DeFi smart contracts, a lot of what's going on is fully collateralized on chain. And this was from an economist's point of view, an incredibly inefficient solution, because why would you just have all that dead capital just sitting on chain doing nothing? Why would you have fully collateralized financial agreements? But it does solve the counterparty risk in a world of full anonymity, because you can trust the Uniswap smart contract because the people who've put money into the pool literally cannot take it out without violating the core rules of the Ethereum protocol and its extension into the smart contract rules of Uniswap. Now, of course, the smart contract could have a bug, but it's a very different approach. It's not necessarily the most sensible approach, and we are now seeing lots of people discussing things like under-collateralized or partially collateralized lending protocols and things on crypto. Can they be built? What will they be like? At that point, yeah, you're going to have a really big counterparty problem if you don't know your counterparties, right?
Again, I want to leave a few minutes in case there are any questions, but this does lead to this broad question of what is the right institution to regulate here? And so to the extent there are centralized institutions offering services, we know the answer, right? Like FTX, we know under the right jurisdiction how we could have regulated them, and we didn't. I agree. I think blockchain offers a unique opportunity, right? So BitMEX was another very large exchange, and they were Bitcoin in, Bitcoin out only. So in some sense, you could monitor the reserves of BitMEX and see, were they doing stuff with the money we had sent them? Were they doing anything with customer funds? It was visible on chain. So that was still a centralized exchange, but it ran in a much more transparent way where the blockchain provided some insights. But again, is a smart contract liable in some sense? And who is liable? If I use a smart contract maliciously, is the author who provided it liable? When I think about investor protections, is there any guidance here? Like, where do we see regulation going?
Well, I don't know that I have explicit guidance, but I think this is a broader problem in the technology area. One of the examples that I often point MBA students to in the regulation space are the issues associated with self-driving cars. So who has the liability with the self-driving car? Is it the writer of the algorithm? Is it the owner of the vehicle? Is it right now at least we have non-drivers who are note takers who are often backup drivers. Whose liability is it? And indeed, I think with respect to self-driving cars, one of the bigger challenges is sorting out these issues of liability as opposed to the technical. I mean, there's still some technical issues like driving around Pittsburgh with the hills and with Pittsburgh's left turn, the Pittsburgh left, and that doesn't match national norms and et cetera. But there's a lot. But I think these liability issues are bigger challenges. Now, one solution that does come to mind is perhaps joint liability, and ideally perhaps have at least the license to the software and the non-driver employed by the same source, so that there isn't necessarily the need to fully split the liability. But I think it points to sort of the challenge of liability in another important context, but a bit of a parallel set of issues.
I guess, so even in the self-driving car example, you at least have the benefit of, in most cases, I know there is actually one group that's trying to work on fully open source self-driving capabilities, but I mean, Tesla or Polestar or Volvo, whatever, like you're usually talking about a major corporation publishing proprietary software that they stand behind or don't, right? The tricky thing with crypto is so many of these protocols, at least certainly the older base layer protocols like Bitcoin or Ethereum, were written by, 300 plus highly involved open source contributors, and like up into the thousands of open source software contributors if you're talking about just like people who corrected typos and things like that. So if you have a software product that's been sort of emergent and jointly authored by thousands of persons, can you hold them jointly and severally liable for the operation of that software product? It creates this sort of unlimited spectrum of liability that would have a massive chilling effect on people's participation in open source software. You'd say, well, I'm not gonna do a pull request to the Bitcoin core repository, because if I do that, suddenly I'm on the hook for trillions of dollars of liability, down the road, potentially. So it's an imperfect solution. What we've sort of looked into in our research at Coin Center, specifically around the Treasury's broker tax regulations, which were the notice of proposed rulemaking came last fall. It's in response to an infrastructure bill from Congress 2 years ago. The question at stake there is who is a broker with respect to tax reporting obligations in the crypto world. Obviously, Coinbase is a broker and needs to know the capital gains of their customers and do the third-party reporting. But is the software author of the Uniswap smart contract or the Tornado Cash smart contract or any other smart contract a broker for these purposes? Is a Bitcoin miner a broker when they put transactions into the blockchain? Do they need to know the capital gains of the, say it's a DEX transaction in the Ethereum blockchain? There has to be a limit to that obligation to surveil other people, and that obligation to be a regulated party in a system where mostly what you've done is publish code. I would argue as a sort of civil liberties advocate that the limit is the First Amendment and the Fourth Amendment. You have a right against prior restraint of publishing, and you have a right to a warrant for any kind of information disclosure to the government unless you've handed your information over to a third party. And a Bitcoin miner is not a third party, so that information can't just be collected from Bitcoin miners. But there has to be more than that. You can't just say First Amendment, code is speech. Like that's not going to win in court. There are nuances to the constitutional law here, and the principle we keep coming back to is sort of a trust or an agency type relationship. There are lots of situations where everything you're doing in your professional life is speech, But of course, your professional life can be regulated. For example, I am an attorney. I had to pass a very annoyingly difficult test about inheritance law, which I'm never going to practice in my life, and pay fairly large fees to the DC bar in order to be licensed to practice. This is a regulation of my ability to speak. But actually, it's not. Because you can write software that gives legal advice, and as long as it says it's not giving legal advice, it's just making general statements about the law in response to predetermined queries from the user, you can publish that software and you can't be charged with the unlicensed practice of law. There's cases about that. Now we've got the situation where you could publish the Uniswap smart contract and it might fit the SEC's definition of an exchange because it's a facility for buying and selling securities. But you can't force them to license before they publish that smart contract because they're just publishing general information, actual software, facts about the world in math and language, and not having any actual individual agency-like relationship with their users. So I'm not practicing law when I'm speaking generally about the law, but if I will go to you or you or you and say, I will represent you in court, I will file on your behalf, I will write briefs, and we're going to do this together. Now there are warranties, there are obvious conduct that can be regulated. If all I'm doing is speaking or publishing code, there isn't that kind of trust agency relationship that I think justifies permission type regulation.
Interesting. I just want to check with our audience. Does anyone have a question perhaps or a topic they want to inquire of our panelists? Go ahead, please.
Is this on? Okay. Nice, that's better. Okay, so a lot of existing compliance solutions like TRM, Chainalysis, they strongly rely on both on-chain and off-chain data. And so, Peter, you mentioned that we're probably going to see a large amount of private transactions and private state in the future because people don't want all these transactions to be public. So how do you see compliance and anti-money laundering checks working when we can't actually track the flow of funds on-chain?
So, a couple things. I would like that to be the way the ecosystem evolves. It's possible I'm wrong, though. I speak from a more civil libertarian perspective. I'd like to see greater privacy, in the world vis-a-vis corporations or vis-a-vis each other, or vis-a-vis the government. But I think a lot of people just want convenience. And so, maybe we don't enter a world where a lot of people use privacy protocols because of the perceived legal risk or other issues, and maybe a lot of information remains on-chain. That would be a bad outcome, in my opinion, because I don't think we should build a particularly important financial system on a fully transparent blockchain. I think that's really bad for human dignity because anybody will be able to find out anything they want about you and discriminate against you or extort you or all kinds of things like that. But if we did see this change, I don't have those answers. I mean, there are lots of really smart people developing, say, zero-knowledge circuits that could specifically reveal and disclose the right information that we want disclosed in a given interaction and not reveal the wrong information. The simple, naive example is on Zcash, one of the early privacy chains. You can do selective disclosure. You can have a view key and you can share that with the exchange and say, yeah, I'm coming to you from a fully anonymous peer-to-peer network, but I can give you my view key and now you can actually see my transactions in the shielded pool revealed back to a transparent address, and you can see that it's actually all me the whole way. North Korea doesn't get involved. And Tornado Cash, amazingly, had a compliance tool that would allow you to selectively unblind your mixing activity on the Tornado Cash pool if you were coming to Coinbase or to a regulator or somebody and say, like, look, it was just me all this time. I didn't take money from some sanctioned person. But that wasn't enough for regulators. And my fear with these more advanced versions of that, like better zero-knowledge circuits to selectively reveal the right information that regulators want, whether from an investor protection standpoint or from an anti-money laundering standpoint, is that the regulators don't want that. They want what they are used to as far as disclosures and KYC. You're telling them you're going to give them some better information that also maintains people's privacy in the process, but might have some other weaknesses. You're going to have an uphill battle convincing them that the literal moon math, which is what Elie Ben-Sasson calls zero-knowledge proofs, is real and works, and is actually better than like the Xeroxed passport photo that was obviously photoshopped, but it's what they've come to expect, right? So, unsatisfying answer, but.
Yeah, that makes a lot of sense. And then I have one other question that's a little bit more general, and it has to do with like core infrastructure providers for blockchains. So for Ethereum, for example, block builders and block proposers are required or ideally required to include all transactions in order to create a permissionless blockchain. But obviously some of those entities are centralized and can still face legal action. So where do you think the legal implications for core infrastructure begins and ends? And should that infrastructure have any legal implications at all?
Yeah, it's a huge problem because if you're a US person who's mining the Bitcoin blockchain and you came to me in my capacity as an attorney, I don't actually have individual clients because I work at this nonprofit, but if you did and said, I'm a US miner, I mine Bitcoin, I'd say, are you doing OFAC screens? Because the SDN list has Bitcoin addresses in it. You're a miner. They might want their transaction in a block. You might be the miner that ends up bundling their transaction and putting it in a block if you win the proof of work for that round. Don't do that because OFAC is a strict liability criminal regime with serious sanctions, or serious penalties rather, for noncompliance. And so that's bad. Well, maybe that's good. I don't know. This is hard. It's bad for what you said was the goal, which is credible base layer neutrality. And even if you believe strongly in America, and I do, and you're very patriotic, you still recognize that this is bad because in a global system, whose particular SDN list should control? Like if the people running this supposedly neutral financial layer are instead beholden to the Chinese government and their idea of what transactions should get blocked and not blocked, then we're in a world of trouble in the US. So like, whose sanctions do you follow? One country's criminal law might be basically human rights violations. Like in North Korea, there's a lot of things you're not allowed to do. And I'm gonna defend people who wanna break those laws. And these networks should actually facilitate people breaking laws in North Korea. I'm all for that. Anyway, yeah.
Thank you.
Well, let's have a round of applause for our panelists, and thank you.